Enlightenment perspectives on truth and justice in legal systems. Ladies and gentlemen, today we gather to examine our justice system through the discerning eyes of the Enlightenment, an era that championed reason, critical thinking, and the pursuit of truth. As we delve into the merits and flaws of the American adversarial system of prosecution and defense, it is essential to consider how this system measures up against Enlightenment ideals. By comparing it with the French inquisitorial model, we can explore alternative approaches that align more closely with these timeless principles. The Enlightenment celebrated rationalism, empirical evidence, and the relentless quest for knowledge. Central to this movement was the belief that human beings, through reason and critical inquiry, could uncover truth and improve society. Yet, the adversarial system often strays from these ideals. In this system, the truth is expected to emerge from a contest between the prosecutor and the defense attorney, each vigorously advocating for their side. However, this competition frequently prioritizes winning over truth and can obscure the reality of a case. Consider the fundamental Enlightenment principle of the presumption of innocence: one is innocent until proven guilty. In theory, this principle is upheld in the adversarial system. However, as soon as the prosecutor begins their opening statement, their objective is to convince the jury of the defendant's guilt. This immediate attempt to frame the defendant as guilty contradicts the very presumption of innocence. The jury, instead of objectively weighing the evidence, is subtly influenced to view the defendant as guilty from the outset. This dynamic undermines the rational and impartial evaluation of evidence, a core tenet of Enlightenment thinking. Let's imagine a scenario: you are a jury member in a trial. As the prosecutor speaks, you can't help but feel swayed by their compelling narrative, even before all evidence is presented. This immediate bias challenges the very essence of the presumption of innocence. In an Enlightenment-driven system, evidence should lead the narrative, not the other way around. Moreover, the adversarial system can perpetuate inequality. Enlightenment thinkers champion the idea of equality before the law. Yet, in the adversarial system, wealthier defendants can afford superior legal representation, which increases their chances of a favorable outcome. Those without financial means must rely on overworked public defenders, resulting in a disparity that Enlightenment philosophers like Voltaire and Rousseau would have decried as antithetical to justice and equality. Consider the case of someone who, despite being innocent, lacks the resources for a robust defense. Their public defender, juggling numerous cases, struggles to provide the necessary attention. This imbalance of resources starkly contradicts the Enlightenment ideal of equality before the law. The Enlightenment also emphasized ethical behavior and the pursuit of truth. In the adversarial system, the competitive nature can encourage unethical tactics. Prosecutors might withhold exculpatory evidence, and defense attorneys might use strategies to confuse or mislead the jury. These practices detract from the ethical quest for truth, reflecting more a battle of wits than a search for justice. Imagine being on trial and knowing that the evidence in your favor might be withheld or that your defense might resort to misleading tactics. Such a scenario deviates from the Enlightenment commitment to ethical conduct and undermines the pursuit of justice. Additionally, the adversarial system can lead to the manipulation of emotional appeals. Attorneys may play to the emotions of the jury, using dramatic rhetoric and vivid imagery to sway their opinion. This reliance on emotion over reason can cloud rational judgment and detract from the objective assessment of evidence, deviating from Enlightenment ideals. Furthermore, the adversarial system can result in an overemphasis on procedural technicalities. Legal battles often hinge on procedural maneuvers rather than substantive justice. This focus on form over substance can result in unjust outcomes and distract from the true pursuit of justice as envisioned by Enlightenment thinkers. Moreover, the adversarial system can foster a hostile courtroom environment. The competitive nature of adversarial proceedings can create an atmosphere of conflict rather than collaboration in the search for truth. This adversarial mindset can hinder the effective and impartial administration of justice. In contrast, the French inquisitorial system aligns more closely with Enlightenment ideals by prioritizing truth-seeking over competition. In France, an impartial judge, supported by judicial police and examining magistrates, conducts a thorough investigation to uncover the truth. This judge-driven process ensures that the investigation is methodical and impartial, adhering to the Enlightenment principle that rational inquiry should guide the pursuit of knowledge. The role of the judge in the inquisitorial system is not to advocate but to investigate. The judge's focus is not on winning or losing but on ensuring that justice is served by uncovering the truth. This approach mitigates the competitive nature of the adversarial system and promotes a more ethical and transparent judicial process. The French system also addresses the issue of inequality. Since the judge actively directs the investigation, the quality of representation does not solely depend on the resources available to the defendant. This creates a more level playing field where the outcome is determined by the merits of the case rather than financial means, resonating with Enlightenment calls for equality and justice for all individuals. In the inquisitorial system, every defendant receives the same level of investigative rigor, regardless of their financial status. This commitment to equality ensures that justice is not swayed by economic disparities. Furthermore, the French system reduces reliance on plea bargains. The comprehensive investigation conducted by the judge lessens the pressure on defendants to accept plea deals out of fear of harsher penalties. This approach aligns with the Enlightenment value of ensuring that justice is based on evidence and reason, rather than coercion. Picture a world where defendants can rely on a thorough, impartial investigation rather than being pressured into plea bargains. Such a system upholds the Enlightenment ideal of justice based on rational inquiry and evidence. Critics might argue that the inquisitorial system grants too much power to the judge, risking bias or abuse. However, the French system includes safeguards such as the participation of multiple judges and the opportunity for appeals. These mechanisms ensure that the process remains fair and balanced, embodying the Enlightenment's commitment to checks and balances in the pursuit of justice. In conclusion, the American adversarial system, while possessing strengths such as the right to a fair trial, often deviates from Enlightenment principles by fostering inequality, encouraging unethical behavior, manipulating emotional appeals, overemphasizing procedural technicalities, creating a hostile courtroom environment, and undermining the presumption of innocence. The French inquisitorial model, with its emphasis on truth-seeking, equality, and rational investigation, offers a compelling alternative that aligns more closely with the values of the Enlightenment. As we strive to create a more just and equitable legal system, it is essential to consider these alternative models and learn from their strengths. Thank you.